O'Keefe files a wrongful death lawsuit against Karen Reed, as well as the Waterfall Bar and Grill and CF McCarthy's, the two bars that they were seen at on January 29th, 2022, just days after Bev denies the motions to dismiss counts 1 and 3. I thought things were already spicy, folks, but they are going to get even spicier in the weeks and months to come. And we are going to cover all that and more here on Alexasrewm. Hello, 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 and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who have opinions about all things going on in the true crime community, including Paul O'Keefe filing a wrongful death lawsuit against Karen Reed as well as the two Canton bars. So this was first broken, I'm going to say probably by Christina Rex, then next by NBC Boston Ted Daniel, who also tweeted about this as well. We're going to get into the lawsuit. We're going to get into what exactly he's claiming. So essentially, this is for the emotional and physical injuries that he has suffered / the family has suffered because of Karen Reed's negligence. Now, I find this timing interesting, and there's a lot of speculation as to why now. A lot of people said it was a long time coming. Some people expected this to happen last year. Other people are saying this is the ultimate grift, and of course he would be doing it now. I personally am not surprised about the civil suit. However, I was really thinking they were going to wait until after the retrial, but now I'm kind of inclined to believe the reason why they are moving forward so quickly with this civil lawsuit right now is because they're seeing the door, or the window of opportunity rather, closing in more and more, and maybe they know something that we don't know, the public doesn't know, about what's actually going on behind the scenes, not only with the federal investigation, which allegedly there's some more bombshells that are going to be dropping, I don't know, in the months to come. That's what's been swirling around the rumor mill. But again, they're only rumors until indictments start dropping left and right. We're not going to report on speculation. We're going to report on fact and fact only, or what is being reported and what seems to be factual. However, I'm inclined to believe that they're not seeing a lot of hope for this retrial. Maybe it's not going to happen, or maybe they're not going to be able to pursue the counts 1 and 3 charges after this appeal process goes through, because as you know, Judge Bev denied the motion to dismiss count 1 and 3, and Karen Reed's team is of course going to appeal this decision. That is going to probably take a little bit of time. Granted, we are not on the docket to go to court again until January 27th, for the retrial. So maybe this is a way of them trying to cut their losses. I don't know. Some people are saying this is the ultimate grift, and of course it's Paul who's doing it. And I don't know, what say you, but let's go through this article and let's go through the actual lawsuit, some of the allegations that are being made. I think it could be interesting because, as we know, in following these cases, following these trials, a lot more can come into discovery in a civil suit than in a criminal trial. So I'm excited to see this. I think this is a great opportunity for Team Karen Reed to get even more into discovery. This will be in front of a totally brand new judge in a civil court. I don't know in terms of whether it'll be open to the press or not. Regardless, we'll be reporting on it as that process continues. But this broke earlier today. This was literally filed this morning. John O'Keefe's brother, Paul O'Keefe, files wrongful death lawsuit against Karen Reed in 2 Canton bars. The brother of Officer John O'Keefe has filed a wrongful death lawsuit against Karen Reed and the 2 bars in Canton, Massachusetts that were among the last places O'Keefe was seen alive. The civil suit was filed Friday. So it was actually filed Friday, but we didn't get news of this until this morning, which again was ironic because we didn't hear from Bev until later in the afternoon on Friday about the motion to dismiss count 1 and 3, because she's always got to leave us on a cliffhanger going into the weekend, right, folks? It was filed Friday in Plymouth Superior Court by Paul O'Keefe on behalf of his family and his brother's estate against Reed, the Waterfall Bar and Grill, and CF McCarthy's. In addition to wrongful death, it alleges negligent infliction of emotional distress. I mean, obviously, you lost your sibling, you lost your brother. I can't imagine what that feeling is like. I'm not going to pretend that I know. So I can understand that, but it's like, are you pulling the metaphorical trigger a little bit too soon? I don't know. It is not unexpected to me, given the sort of the posture, oh, I guess this is a typo, sort of posture of the O'Keefe family. Catherine Loftus of Note My Objection podcast said of the 22-page lawsuit. I guess we're quoting podcasters now. Legal experts tell us a civil case comes with different rules, with a different burden of proof. Yeah, just like I was saying, there's a lot more that can come into play here, whereas opposed to the criminal trial and the criminal case, there's a lot more restrictions as to what can come in, etc. In a civil case, it's what we call a preponderance of the evidence. So it's 49 to 51% more likely than not that someone is responsible for the death, Loftus said. As an example, the civil suit alleges Reed said this to O'Keefe's niece in the hours before O'Keefe's body was found. JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. NBC 10 Boston legal analyst Michael Coyne says this also sets up a big choice for Reed. If she testifies in the civil suit, which is, I mean, I don't know how likely or unlikely that is. I would assume so. The chances are more likely than not. It could be used against her in her criminal case. If she doesn't, it could play a big factor in her civil suit. It really creates a catch-22 for her, he said. The exercise of that right raises the presumption that the answer would be harmful, and juries will take that in a civil suit legitimately. So essentially, what they're saying, from my understanding, is whatever goes on in the civil case, if this happens before the retrial in January, and unless for some reason that gets pushed off even further into the future, which is always possible. I mean, we've seen what's going on with Koberger in that case. I mean, that's the case that just keeps on adding more and more time. So we won't be in trial for that until next year, but anything is possible. But they can use essentially whatever is said, whatever is documented in this case, in this trial for that, for the criminal case later on. These legal experts also say that the criminal prosecutors will be watching this closely. So, yeah, maybe Lally will actually learn how to question somebody. To see if anything new comes out ahead of Reed's second criminal trial. Neither Reed nor the two bars named in the suit could be reached for comment Monday. I mean, without even reading this yet, because I haven't read the whole thing. I've only read bits and pieces of it, some quotes from it. It's 22 pages long. Again, we'll go through the whole thing. It's a pretty easy read. It's just, line by line, what they are alleging, um, outlining what the specific things that they're suing her for, etc. The two bars, how they're responsible, yada yada yada. I think they're ultimately going to get dropped from the civil suit, just because, I mean, at that point, then okay, you got to depose the bartender again, right? And probably I don't know, whatever manager was on site that night. I would imagine probably a lot of the same faces from the first trial would be deposed again for this lawsuit, but maybe even more of the employees, the staff, extracting the CCTV and going through that again and looking and seeing if there are actual receipts that we can pull that really do show, okay, this is the number of drinks that were served to her. But then the counter argument would be, how many drinks was everybody else being served? Was she actually overserved by these bars? And I just don't think there is any weight to that evidence, not at least that we've seen from a criminal level, but maybe more will come out in this civil suit. But I imagine that the owners of both the Waterfall and CF McCarthy's, since they aren't there, it's not like they're franchises. These are local hubs, local watering holes, as I gather. Um, they got a reputation. They got a local reputation to protect. They're not like McDonald's. They're backed by billions and millions of dollars. So I a lot of people are like, "Oh, they'll probably settle, yada yada yada." I don't know. I don't know. Um, but it'll be interesting to see how this goes down. So I want to now get into the suit itself and what exactly they're alleging here, what kind of emotional or physical distress, specifically Karen Reed's negligence, as well as these bars that have been supposedly responsible for over serving, which is also interesting too, because it almost feels like they're kind of admitting that it was because she was overserved. Whereas I feel like with trial, the whole theory during the entire trial was that it was leading up to that moment, like, John was pushing her buttons and they were arguing, and they got into a screaming fit in the car when they were waiting outside of 34 Fairview, and, yeah, she had too much to drink too, so it's interesting because I feel like they didn't put a lot of weight on this during the actual trial. They put more weight on the relationship and trying to highlight how toxic it was between the 2 of them, so I don't think the suit in regards to the 2 bars is gonna go far, but hey, what say you? Let's go through this and let's see how we feel after this. So, parties jurisdiction. 1, the plaintiff, Paul O'Keefe. Paul is the surviving brother of the late John J. O'Keefe. The third, oh, I didn't know he was a third. JJ, John, or decedent, and is the duly appointed personal representative of the estate of John Joseph O'Keefe III, who died on or about January 29, 2022. At all relevant times, material hereto, the decedent resided in Canton, Norfolk County, Massachusetts. At all relevant time, materials hereto, the plaintiff Paul resided in West Bridgewater, Plymouth County, Massachusetts. So I guess I'm assuming that's why he's filing there. The plaintiff, John O'Keefe, the second, so that's the father, I didn't know he was also John O'Keefe too. Did you guys know that? I didn't know he was also a John O'Keefe. Okay. The second is the surviving father of JJ and Kristen. At all relevant times, material here too. The plaintiff, John the second, resided at One Meadows Avenue, Canton, Norfolk County, Massachusetts. The plaintiff, Margaret O'Keefe. So they're going through everybody who is in this lawsuit. Margaret is the surviving. So this Peggy is the surviving mother of JJ and Kristen. I also feel like, and I don't want to be mean, right? I don't want to be mean. Like, I get it. I definitely sympathize with the fact that they lost a family member. They lost a son. They lost a brother. For many people, a close friend, an uncle, slash father figure as well too. So I really don't want to drag the family too much, but I just kind of gives me a little bit of the skeevies when they keep referring to Officer John O'Keefe as JJ, even with like these court filings. It just kind of gives me a little bit of that ick factor, like they're claiming him, and like nobody knows us. Nobody knows him better than we do. And of course, you're his family. Of course, you know him. But it just kind of gives me like that, almost like they're trying to distance like their family from everybody else. And almost kind of, I don't know, like it's almost like an extra sympathy card. It just gives me a little bit of an ick factor. Not to be too picky over that, but I had said that too in my last video with his college buddy who allegedly was so close to him, yet didn't meet Karen Reed ever, even though they were dating for over 2 years. But it's just my opinion. I just feel like it's a weird thing to keep referring him to, especially specifically in a court document, right? Anyways, I digress. And then this is his niece, which they name in the in this filing, which I find is interesting because they don't mention the nephew. So I don't know why. I guess because they're not going to depose the nephew, they're only going to depose the niece. But why not? I mean, they were both deposed and both subpoenaed to be called in the trial, so why not put them back both on the stand, right? I mean, this is just gross. This is like extra ick factor for me. But anyways, um at relevant times, the defendant, CC and Hospitality LLC, doing business as CF McCarthy's, is independently known. Okay, yada yada yada. Skipping through the Waterfall Bar and Grill. Um, okay, and then Karen Reed as well too. So now these are the facts. These are the facts according to Paul O'Keefe. Plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. The decedent JJ, like, I also feel like it's low key kind of disrespectful. Like you make such a big point to not forget him and not forget who he was. But I mean, he was. I feel like it's kind of disrespectful to not call him, refer to him as Officer John O'Keefe. Like, let's not forget that. Let's not forget that he was a police officer, right? So that also just, I don't know. But anyways, the decedent JJ was the middle of three children in a tight knit family. JJ was a third generation Boston police officer. After the tragic death of JJ's sister, Kristen, and brother in law, Steve, JJ took custody and guardianship of his niece, Kaylee, and nephew, Patrick, who were 6 and 3, respectively, over the next 8 years until his tragic passing. JJ raised and supported his niece and nephew. After the tragic death of JJ, so Peggy, took guardianship and custody of her grandchildren at all relevant times on or before January 29, 2022. JJ and defendant Reed were in a dating, this is such a weird way to say it, were in a dating relationship. Like they were in a relationship, a dating relationship. That's weird. In the months, weeks, and days leading up to January 29, 2022, JJ and defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights. So again, they're going back with the angle of she's the crazy girlfriend, guys. She's unhinged. She's the crazy girl who's just jealous and obsessed and paranoid. And like she's scary. She's so scary. She's that crazy girl that you don't want to end up on the bad side of the bed from, right? Experienced jealousy and had delusions of unfaithfulness. I mean, not for nothing, I would be if he was texting it, like, and I'm just saying, if he was my man and I saw he was texting somebody like Jen McCabe, I'd be like, what the actual F? Like, first of all, really? Like, really? Okay. I mean, if that's your sort of thing, if you feel like you need attention from that, but I mean, you get all these girls who are constantly texting him and constantly like, we all saw the trial and how the Sullivan sisters were like salivating over him practically. I mean, come on now. So I don't think it's really that delusional for her to be a little insecure in their relationship, and that's fine and fair. Obviously, she felt that way if she is letting Brian Higgins give her a little bit of attention. So we've all been, girl, I've been there too. I've been there. I've talked to guys that, and it's not the best thing to do, but sometimes you feel like you're not getting that attention that you're craving, and you reach out for alternative ways to get that attention, and that's all it is sometimes. But I digress. We don't actually know what happened in their relationship. The only people who know is Karen Reed and John O'Keefe. And unfortunately, John O'Keefe is no longer with us. So We don't know. We just don't know. This is all just hearsay nonsense for me. On or about January 28th, 2022, defendant Reed knew that her relationship with JJ had run its course. Like, can we just, like, he's also a man too. Can we, like, call him John O'Keefe? I don't understand. This is just icky. I'm going to call him John O'Keefe because I can't. JJ, I cannot. On January 28th, 2022, or at or about 8:51 p.m., plaintiff arrived at CF McCarthy's. CF McCarthy's was licensed to distribute, sell, or serve alcohol. So first they're saying, oh, she's a crazy, jealous, delusional girlfriend. And now they're like, but it's also the bar's fault for fueling that. On January 28th, 2022, at or about 8:58, CF McCarthy served Reed an alcoholic beverage. Reed consumed said drink. On January 28th, 2022, CF McCarthy's, through its agents, servants, or employees, served alcoholic, you mean bartenders? So weird. Served alcoholic beverages to defendant Reed at or about 9:13 p.m., 9:20 p.m., 9:33 p.m., and 9:57 p.m., and 10:22 p.m. and 10:29 p.m. Reed consumed such drinks. CF McCarthy's, through its agents, servants, or employees, served defendant Reed 7 alcohol. So this is weird. So okay, so they're like listing out the times and then they're just repeating it and saying, oh, they served her 7 drinks between 8:58 and 10:29, and maybe that's true. I feel like we never got an exact, like, specific answer as to whether or not she consumed. She said, I know she said in her interview with what was it, Dateline, like a year and a half ago or so, that she had about 4. I mean, 4 to 7, okay. But is there legitimate proof? I know we saw some of the bar receipts as well too. And you know what? I might actually go back to some of that testimony from one of the bartenders. Let me go pull that. So this is from shout out to Nurse Kim for pulling this. This is from the Waterfall Bar and Grill bartender who was serving Karen Reed and everybody, the McAlberts, etc., who came from CF McCarthy's because they went there first. So the reason why I want to play this clip is because, again, just jumping really quick back to this lawsuit where they're alleging she had 7 drinks. Now, and again, we know Karen Reed's a very tiny woman. She also has gut problems. So drinking a lot, I would imagine, could do quite the number on your stomach, right? Especially if you have health problems. I don't know if she's on any medication. I imagine she is, so she probably also has to kind of watch what she's drinking, not drinking. Now, she did admit in her Dateline interview, I believe, that she had about 4. So but again, note, if they're alleging that she had 7 drinks at CF McCarthy's, then by the time the Waterfall hit, she would be probably pretty tipsy, would she not? That's just my speculation. That's my speculation. So I want to play this clip from, thanks again, shout out to Nurse Kim for digging this up, from the trial cross-examination of the bartender at the Waterfall.
Is a pretty good tipper.
I wouldn't really know.
But with regard to that particular night, there was one receipt that was introduced in Exhibit 54. You probably didn't take a close look at it.
No.
But if I suggested to you that there was a receipt for a total of $16.58 worth of drinks, and John put a tip down of $10, that'd be a pretty good tip, right? And do you need to see the receipt to confirm that, or?
No.
That makes sense?
Yeah.
Okay. And that night, John's demeanor seemed fine. Would you agree?
Yes.
You didn't notice John buying drinks for a woman that night, did you?
No.
And with regard to your, sort of scanning the people that were there within that group, one of your duties as a bartender is to make sure that nobody's overserved, right?
Correct.
And so, while
Because if you do, you get sued.
Well, you don't watch every movement all the time. You do look for signs that somebody might be overserved, correct?
Correct.
And with regard to the group that came in, the receipts for which you were shown today, nobody really seemed highly intoxicated to you, correct?
No.
Let me just have a moment.
Yes.
I have no further questions. Thank you, ma'am.
So no one seemed intoxicated at the waterfall. Which is, I mean, it's interesting. Like, what is this? This is the thing. What does this bartender have anything to by lying? Like, she absolutely. What would be the point of her lying about whether Karen Reed was drunk or not drunk? I mean, she didn't know these people from Adam, right? I mean, maybe she did. Maybe they came there a lot. Maybe they were regulars. I don't know. I'm just speculating here, but I mean, I imagine, and again, working in the bar business for a hot minute when I was dancing, there were definitely a handful of times where we had to kick out people for drinking too much, who wanted to continue, who would push and push and push, and ultimately would get thrown out because they were way too intoxicated to keep drinking, and sometimes they'd even pass out of the bar. But whatever, I digress. So all this to say, if this little teeny tiny woman is drinking, and this is like a really short window of time to drink 7 drinks, and I think they were saying she was drinking vodka and seltzer too, so like that used to be my drink back in the day, and like that would rock my socks for sure. So I don't she would have been probably a little visibly tipsy, unless I don't know, maybe she ate some food. I don't know, maybe she has a better tolerance than I do, but I just know that based on my size personally, I know that 7 drinks, I mean, I'm walking, but I'm wobbling. I'm definitely wobbling. So but at that point, when she gets to CF McCarthy's, she doesn't appear, according to, or excuse me, by the time she gets to the waterfall, she doesn't appear to be intoxicated. So let's read on. During all relevant times at or before 10:29 on January 28th, defendant Reed showed signs of intoxication while at CF McCarthy's. Not at the waterfall, though. On January 28th, at or about 10:40 p.m., John O'Keefe, Officer John O'Keefe and defendant Reed left CF McCarthy's. Okay, so 10:40, they're out. January 28th, at or about 10:40 p.m., defendant Reed was allowed to carry her alcoholic drink out of CF McCarthy's. On January 28th, 2022, at or about 10:54, Officer John O'Keefe and defendant Reed entered Waterfall together. Okay, so like, and that, I mean, that's a 14-minute that's a 14-minute, I guess, drive, walk, however long. I don't know how far the waterfall is from CF McCarthy's, but 14 minutes is not enough to get you like stupid sober. Like if you're 7 deep, you're still like, that's when it's really starting to like hit you. Like it takes that minute to actually hit you. So I'm just not buying, like, either the bartender's lying or somebody else is just falsifying the actual facts here, or maybe over exaggerating how intoxicated she may or may not have been to make your story make sense. At all relevant times on January 29th, while at the she walks in to the waterfall carrying her drink from CF McCarthy's. I mean, do we know if there was, like, an actual drink in there? I mean, maybe there was, I don't know. But, at all relevant times on January 29th, while at the waterfall, defendant Reed showed signs of intoxication, but not according to that bartender. No. So that's a lie. Between 10:54 and 11:54, defendant Waterfall served Waterfall served defendant Reed 1 shot and 1 mixed alcohol drink. Reed consumed such drinks. On January 29th, 2022, at approximately 12:10, defendant Reed left the waterfall. So they're alleging here that she had 1 more drink. So 8 drinks total, which is, I think, what Lally eventually. I think they're just trying to match it up with, oh yeah, that's what Lally said during the trial, so we're gonna match it up to that. On January 29th at approximately 12:11, Officer John O'Keefe left the Waterfall. At all relevant times on January 29th between 12:11 and 12:36, Defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. I mean, I think everybody was intoxicated, so everybody, like, how much did everybody have to drink? I think that's the question that we really need to, ask ourselves here. Nobody probably was able to drive or operate a motor vehicle safely. So that's the lesson in all of this, kids. Don't drink and drive. At all relevant times on January 29th, Defendant Reed drove Officer John O'Keefe to the residence of 34 Fairview in Canton, Norfolk County, Massachusetts. Defendant Reed and Officer John O'Keefe had been in an argument that night of January. See, but what? No. No, this is where you're losing me. This is like really where you're losing me, because it seemed like they had quashed their disagreement. They had quashed everything by the time they get to CF McCarthy's, where they're seeing on video and like she's all chummy, laughing, smiling, and then they get to the waterfall. Everybody said they seemed happy and fine. So that's not correct. So yes, were they having issues during the day? Sure. But anything after that, between them leaving in the waterfall and them getting to 34 Fairview, that's all pure speculation. There's no actual proof. It's not like Ryan Nagel was like, I saw them fighting in the car. That's actually the opposite of what he testified to. So I'm just wondering, like, what? This is all just based on your own. Well, not even your own theory, but this is all based on the theory the Commonwealth has put together. And that's why I'm really inclined to believe that this is almost like the O'Keefe's family's second strategy. Like, oh, maybe they're not as hopeful for round two as all the blue shirt people, right? Believe to be super excited about the retrial. Maybe they don't feel as confident in the Commonwealth in the prosecution's theory than they were for round one. So I don't know, but what say you? After Officer John O'Keefe got out of Defendant Reed's vehicle in front of 34 Fairview on January 29th, Reed drove her SUV and hit John O'Keefe. At all relevant times on January 29th, 2022, Defendant Reed drove her SUV in a state of intoxication. As a result, and you know what else too I find interesting? I really think they're homing in on this now. Really homing in on the fact that she was driving while under the influence, and like less of like they did bring up, oh, she's the crazy jealous girlfriend, yada yada. But now they're really leaning in on the driving while under the influence, because that was the count that the lesser included charges is what the jury was hung up on. So I am kind of inclined to believe, like, okay, maybe this is them kind of, like I said, this is like plan B if the retrial doesn't go the way that they want, because they know they probably have a better shot at maybe winning the civil lawsuit, using this theory as opposed to, hey, she intended to in the exact moment it was happening. So Officer John O'Keefe, as a result of Karen Reed's SUV hitting him, was knocked down onto the ground in front of 34 Fairview, suffered serious injury, and died. After hitting Officer John O'Keefe with her SUV, Defendant Reed fled the scene and returned to Officer John O'Keefe's residence at 1 Meadows Avenue. At all relevant times, Defendant Reed knew it was snowing, knew there was an impending blizzard, and knew, or should have known, that leaving Officer John O'Keefe outside in the blizzard would likely... Yeah, so this is them like really tying it up, wrapping it in a bow to match the Commonwealth's theory, based on the charges. Which ties in, again, to the count 3 charge. So it's like really bizarre. It's really bizarre to me. like how they're like picking and choosing certain things to highlight from that. But anyways, at all relevant times when defendant Reed drove her SUV and hit Officer John O'Keefe, defendant Reed A, failed to use any care to avoid creating an unreasonable risk of harm to the public, and Officer John O'Keefe voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable, persisted in a clearly negligent course of conduct over a noticeable period of time. D, was impatient with reasonable precautions. E, was deliberately inattentive to the predictable hazards of her actions. And or F, was deliberately inattentive when there was a risk of great and immediate danger. So it seems like she has, I mean, it seems like they're laying it out of like, well, we don't really actually know because there's this and or. So that's kind of how I'm piecing it together. I don't know how you guys interpret that, but that's what it seems to mean to me. Is they're not saying, oh, she was all of the above, but it's and or it was one of these. That's kind of how I'm reading it. But what say you? 38. At all relevant times when defendant Reed drove her SUV and hit Officer John O'Keefe, defendant Reed was reckless when A. This seems like a multiple choice, like pop quiz, right? A. She intended the reckless conduct that resulted in Officer John O'Keefe's injuries/death. B. Her conduct made it highly likely that someone, namely Officer John O'Keefe, would suffer serious injury or die. So, like, this almost makes it feel like they're saying, well, maybe she acted recklessly, but didn't but didn't know she was gonna hit him. Like, so bizarre. It's so bizarre. C, she knew or had reason to know of the risk or of grave injury to death to Officer John O'Keefe, or said risk would have been obvious to a reasonable person. And D, she intentionally or unreasonably disregarded that risk. Or E, John O'Keefe's injuries and death resulted from defendant Reed's decision to engage in the conduct referenced in above 16 through 70, yada yada. 39. On January 29th, 2022, at approximately 4:30 a.m., defendant Reed knew that she hit Officer John O'Keefe with her SUV. Why? Because she said, I hit him, right? Nevertheless, she woke up at his 14-year-old niece and talked about Officer John O'Keefe's death, talked about hitting Officer John O'Keefe with her SUV, and otherwise involved his niece in her frantic calls about. Wow. Okay. All right. Okay. At all relevant times on or about January 29th, defendant Reed knew that Kaylee was a vulnerable minor who already lost her parent tragically and depended on her custodial uncle, Officer John O'Keefe, who became her surrogate parent. Are you effing kidding me here? What in the world is it? What are you trying to say with this? Like, she took advantage of the fact that she knew that she was I mean, okay, this is like sick. I don't even like that they name her in the lawsuit. What is the point? What is the actual point of this? Oh, she knew that she lost her parents tragically and depended on her uncle, and like, how dare you, Karen Reed, take advantage of this poor vulnerable Maya? What are you doing by putting her through all of this? What does that say about you guys? The fact that you're literally naming her as a plaintiff in this lawsuit. Like, come on now. Come on. At or about 5:07 a.m. on January 29, 22, defendant Karen Reed left One Meadows between 5:18 and 5:35. Karen Reed knew John O'Keefe was seriously injured, buried in the snow and laying on the ground in front of 34 Fairview, where the defendant left him to die hours earlier. This is the thing that I always didn't make sense to me too, is like, if she knew she did it, which she didn't. But if she knew, she did it, and she did do it. Not in this world, but in delusional world. If that was the case, then why would she intentionally go back to the scene of the crime and say, "Hey guys, I found him"? Like, that is like the best way to make yourself look super, super guilty. But what say you? What say you? On January 29th, the defendant admitted repeatedly that she hit Officer John O'Keefe, which was allegedly only heard by Katie McLaughlin. So what, are they going to call her again? I guess so. They're going to have to depose her. And we'll see if anybody else says the same thing too, but they didn't during the trial. At or about 6:03 a.m., defendant Reed arrived at 34 Fairview, Canton, and immediately observed Officer John O'Keefe laying on the ground, buried in the snow where she had left him earlier to die. At relevant times on January 29th, like, what does this even mean? They don't even know. Like, they can't even pinpoint certain timelines. Like, they only name the times when it suits them and their story and their theory. Also, I don't think he was buried in the snow. I think he was. Didn't, like, Jen McCabe too say he was like face down in the snow? Didn't she also say that on the 911 call, or am I misremembering that? I thought I heard that. At relevant times on January 29th, whatever that means, um, Officer John O'Keefe suffered trauma injuries before becoming hypothermic. At or about 7:50 a.m. on January 29th, he was pronounced dead at the hospital. So we're not even going to say what hospital it is. Okay, at the hospital. The only hospital. It is the hospital. At relevant times after 7:50 a.m., defendant Reed went to the grieving house of I mean, like, this is where, like, and the constant, like, need to call him JJ, oh, it just, like, irks me so much. It's just so gross and, like, exploitative, in my opinion. Feigned comfort to his family and used the opportunity to, amongst other things, remove the offending weapon, her remove the offending weapon, her vehicle, and or destroy relevant evidence, which we learned that wasn't true because she didn't even have access to the Ring camera app. She didn't want to add herself to it. She didn't. This was testified by the same niece who's named in this lawsuit. So where are you getting this information from? And I get it. I get it. You're all mad. This is what they're all mad about. They're mad about how she acted that morning, and that is what everybody is basing her guilt on. And I understand it could come off as, what the heck? Like, we invited you into our home, and, like, we think of you as part of the family. I know Paul O'Keefe did, at least at that point. He didn't have a problem with her, as he shouldn't have, because she bailed him out of jail for his drunk driving incident. So, but here's the thing, everybody grieves and processes trauma in different ways. I mean, can you imagine? And maybe some of you have, and if you have, I'm so sorry that you went through this, but can you imagine seeing the person that you love, and, like, regardless of all the crap that you went through earlier that day, probably even more so the emotions, the emotional weight you would carry in that moment, and, like, all the confusion, all the mixed feelings, and you're still probably processing, like, there's no way he's actually dead. He can't be dead. Like, this is not real. This is not reality right now. And I not for nothing, I probably wouldn't want to be around anybody. And I'm extremely close to my wife's family. But if this happens to my wife, like, God forbid, if something like this happened to my wife, I would be an absolute wreck and I would not want to talk to anybody. Not my own family, not her family, nobody. Because I would not know how to frickin' deal. But then again, it's like, maybe I wouldn't react that way. I don't know, because no one knows how you're supposed to react in those moments, because nobody plans. There's no playbook on how you are supposed to grieve and how you're supposed to respond to trauma. And that is a traumatic experience. And I'm sure for anybody who had witnessed it, anybody who wasn't, a EMT or first responder, somebody who's trained and who's used to seeing this kind of thing. But for Karen, I mean, I cannot even imagine. So I feel like it's not fair to place the entire weight of this case on how she acted that morning. I mean, you think about all the 911 calls, and people say all the time, I get it. Like, sometimes it comes off a little fishy or suspicious when you hear certain people, but then you find out from the actual physical evidence later on in the trial that maybe they were just processing their grief in a weird way. And it's weird because most people, this is not a common thing. This isn't something that happens to most people. This is a very unique situation. So I think this is just so like, this just isn't, if this is what we're going off of, okay, okay, all right, fine. And we know this is what the crux of Paul O'Keefe's whole reason for hating Karen is this morning. Is this morning. I mean, she barely even had any sleep. She didn't even sleep. How would you react? I don't know. I don't know. Especially when you know the mom's already blaming you for it. Right? Like, I wouldn't want anything to do with Peggy and her family at that point. I wouldn't. And maybe you are feeling some of that guilt because you're the one who dropped him off at 34 Fairview. But anyways, continuing. On January 29, defendant Reed's blood was drawn reading of 93 mg/dl. A serum conversion and retrograde extrapolation was done of the results of defendant Reed's blood, with the results showing her BAC would have been between 0.13 to 0.29%. After around the time she drove the SUV and hit Officer John O'Keefe, Reed's BAC of 0.13 to 0.29% all exceeds the legal limit to drive a motor vehicle in Massachusetts. So I have to go back to that testimony. I'm not gonna lie, I don't fully remember everything that was testified to. It was a lot of like scientific mumbo jumbo that kind of went over my head at the time. But I know that there was a range. So we'll go back and we'll do some digging on that. This was an article because I wanted to pull it up and I wanted to fact check just because I couldn't really remember too much from this guy's testimony. Justin Rice. He was an emergency room doctor at Good Samaritan, the hospital, aka in Brockton, where Officer John O'Keefe passed. He treated Reed the morning of January 29th. So essentially, she was brought to the hospital just before 8 a.m. under a Section 12 order. He described it as involuntarily detention, usually over a mental health concern. Rice said blood work was performed on Reed. She had a blood alcohol content. So again, BAC of 93 milligrams, which according to the lawsuit, they did include here. That's accurate, or 0.093%. The legal limit is 0.08 for driving. Later, Nicholas Roberts, who was at the time was a member of the Massachusetts Office of Alcohol Testing. So yeah, I remember a little bit from his testimony, but he talked about the actual retrograde testing that allows them to estimate, and that's the key word, is estimate what a person's blood alcohol level would have been hours before an official blood test was taken, because her blood was only taken at 9:08 a.m. and they were using the 12:45 a.m. as the estimated last drink, which, I mean, essentially makes zero sense because she was already out the door of the Waterfall. So that already doesn't make sense. If we're using 12:45 as the estimated last drink, when that was also allegedly after she already mowed down Officer John O'Keefe, how does that make sense? Make it make sense. And regardless, and I liked his testimony because he was very like factual. I remember this. He was very like straightforward to the point. Didn't get overly emotional in his testimony or anything like that. Just very, Yes or no. Yes, that could be possible. No, that can't be possible, etc. As the estimated last drink Reed consumed, Roberts estimated that her BAC would have been previously been a minimum of 0.135% or a maximum of 0.292%, which again, just flipping back to this lawsuit over here, they're stating, which they don't even mention the time frame of when her alleged last drink would have been, because it really doesn't make any sense. With results showing it would have been 0.113% to 0.29%. Where again, as here, I mean, yes, that's a rough estimation, but again, they're estimating based on if that was in fact the last time her last drink was, which was, as we know, much earlier than that, about 2 hours prior to that, right? Or at least an hour before that. Defense attorney Elizabeth Little spent cross-examination of Roberts, attempting to show that the estimation could have been inaccurate. She said the testing method is acting with a lot of unknowns. Miss Reed drank alcohol after 12:45 and before her blood was drawn at 9:08. Your entire calculation would be invalid, Little said, and he responded, yes. It would be it would be invalid. And I do recall that part of the testimony, but whereas here in this lawsuit, they're saying, no, she was definitely. And I mean, again, going back to her mental state and her mental condition, like, was she visibly intoxicated when she was at Good Samaritan? That kind of really muddies the water for the Commonwealth, but even more so for this lawsuit, since that's what we're talking about here. So, defendant Reed drove her SUV while under the influence of alcohol and hit Officer John O'Keefe with her SUV as a direct and or approximate cause of Reed's drunk driving. Officer John O'Keefe sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. I gotta read that again. As a direct and or proximate cause of Reed's drunk driving, Officer John O'Keefe sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. So now they're saying, like, oh, because you allegedly, but not factually, mowed him down, you caused all of this stuff that we don't want to pay for. Essentially, stuff that we didn't want to have to pay for and we paid for. Notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. But none of that is proven whether it was false or not false. Any more true or not true than what you're claiming here in the lawsuit. She publicly communicated this false narrative, thereby frustrating justice for, oh my God, did Jennifer McCabe write this? Jeez Louise. Ugh. Such false narrative caused the plaintiff's aggravated emotional distress. How much you want to bet, like, Jen McCabe was like, you should sue Paul. Paul, you should really sue. How much you want to bet? My God. Justice for JJ. Like, that was a Jen McCabe thing, no? This stinks of Jen McCabe. The plaintiffs listed above bring this complaints seeking full and complete justice for JJ. Yeah, oh my God, Jen McCabe. Maybe she maybe she filed this under the guise of Paul O'Keefe. Just my speculation. Just kidding. You see it, John Joseph O'Keefe III versus C.F. McCarthy. So I guess this was all against. Oh no, this was just laying out the facts. Okay, this is just all laying out the facts. Now we're breaking this down based on C.F. McCarthy's. The estate repeats, realleges, and incorporates by reference as set forth hereto in their entirety prior paragraphs of the complaints. Defendant C.F. McCarthy negligently served alcohol to an intoxicated person, namely Defendant Reed. Defendant knew or should have known that Defendant Reed was intoxicated at relevant times of service on January 28th. And I just saw like a whole like compilation that I think Turtle Boy just shared.
While you were speaking to her, you had no indication that she was slurring her words in any way, correct?
I didn't think so, no.
No. Her eyes didn't appear to be bloodshot and glassy, correct?
Correct.
She wasn't swaying or stumbling in any way, correct?
Correct.
She didn't appear to be confused in her thinking or her speech.
She did not.
She appeared to be normal, correct?
Yes.
There was nothing about her demeanor or her interaction with you that would lead you to believe that she was under the influence of alcohol at that time.
No, not.
While you were Karen did not appear to be under the influence of alcohol to you.
I didn't notice anything.
She wasn't stumbling, correct?
Nope.
She wasn't swaying.
I didn't notice.
She didn't appear to be unbalanced, correct?
I didn't notice anything.
She wasn't slurring her words.
Nope.
She wasn't talking gibberish, correct?
No.
She was engaging in normal conversation and she appeared to be under control.
Yeah.
And Karen did not appear to be under the influence.
At any point while you were at the Waterfall Bar and Grill, did you observe Karen Reed stumbling, slurring her words, or otherwise appearing to be under the influence?
I did not, but again, I never engaged in any sort of conversation with her.
At any point,
So there you have it. I mean, granted, like, you know, those aren't all people who were, and we had Chris Albert, Nicole Albert testifying on that, but like the people who were part of this alleged cover up, right? You would think that would be the thing that they would lie about. Oh yeah, sure, she was slurring her words, she was a stumbling fool mess, but they probably know because there's cameras, there's security cameras, right, that are filming the inside of the bar, so can't really lie about that because camera sees everything. Camera sees everything. So there's not really way around that one, and they knew that they couldn't lie. So I mean, there was nobody had testified. Nobody had testified that she was intoxicated at CF McCarthy's or at the Waterfall. Defendant CF McCarthy violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including but not limited to its decision not to hire competent employees, staff, bartenders, servers. Yikes! I mean, like, dang, like you gotta throw like that. Well, she was a Waterfall, but I mean, they're probably gonna allege the same thing too. I mean, that, like, what the heck, man? Those are your people. That's your community. Well, I guess because you live in Plymouth, so it doesn't matter. It's not your community, but I mean, these are people probably that knew your brother. Like, and you're just totally gonna be like, oh, F you, bar. Even though you didn't seem to have a problem with them early on in this, right? Only when it suits you. But B, its decision not to provide adequate personnel to work at CF McCarthy's at relevant times. Its decision not to provide adequate safety training to its employees, staff, bartenders, or servers. Safety? What do you mean adequate safety training? What, for somebody who... I mean, if any of you guys have worked in the bar business too, you know, we've all had to deal with somebody who was definitely is visibly intoxicated. Like I said, I've definitely seen a number of people pass out on the bar, like puke on the bar, because they were so intoxicating. Usually, like, I mean, not so much like safety procedures, but usually the procedure is like, hey, call them a cab. Hey, if they're with their friend or their buddy, you know, escort them out, ask them to leave, you know, square up, settle up, ask if they need help calling a cab or getting an Uber. Sometimes the girls even would help. There were a couple times where I hooked up one of my customers with a different customer and said, hey, like, would you mind taking them home or helping them like get into the cab? So its decision to violate its safety training, its choice to retain unfit employees, its choice. So they're like totally just throwing the staff under the bus. Choice not to supervise adequately its employees, staff, bartenders, servers. The defendant, C.F. McCarthy's, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. The defendant, C.F. McCarthy's, acted with gross negligence. The defendant acted with willful, wanton, and reckless disregard for the safety of others when it served intoxicated defendant Reed. I mean, how many other intoxicated folks did they serve that night who was on that witness stand? So, I mean, come on now. And also, Paul, you would know something, right, too, about drinking and driving. Don't think we forgot about your whole past too, there, buddy. Deliberately ignored the appreciable risk, or I think appreciable risk and or voluntary incurred the obvious risk of serving defendant Reed when she was already intoxicated. I mean, this is just like all of the same, like, you served Karen Reed alcohol at relevant times when she was already, like, it's just saying the same thing. Like, did Morrissey write this? Jeez. As a direct and proximate result of defendant McCarthy's gross negligence, what? McCarthy's negligence, gross negligence, and or willful wanton. Now I want Chinese food. Disregard for safety. Officer John O'Keefe sustained injuries, serious injuries of body and mind, conscious pain and suffering, fearing of impending death, lost earnings, and medical. So the same thing that they list in the facts above as a direct and proximate result of C.F. McCarthy's negligence. That his next of kin also suffered as well. His next of kin are entitled to. So he's trying to claim, like, we're doing this for the kids. We're doing this for the kids. Are you, though? Are you? Next of kin are entitled to Officer John O'Keefe's lost value resulting from his wrongful death. Such damages include, but are not limited to, reasonably expected society, companionship, comfort, guidance, counsel, net income, services, assistance, protection, care, and advice to each next of kin. Okay, so that's the lost value. Almost like, it sounds so gross. It sounds like he's like a commodity, right? Like, he's just this is so, like, gross and expletive. Like, oh my god, this is so exploitive. Like, I was really, oh man, I was trying to, like, I'm so conflicted about the O'Keefe family. I really am. Such damages reasonably expected society. Like, what what does that mean? Expected society, companionship, comfort, guidance. So, like, and then net income. They, like, squeeze that in there, right? Because we're doing this for it's about the kids, but I thought it was about you, Paul. Demands judgment against the defendants. C.F. McCarthy's on count 1 plus costs, compensatory, and punitive damages, lost value to the next of kin, and any other relief this court deems appropriate. Count 2. Okay, so this is against a Waterfall. And then we'll save the best for last, right? Karen Reed. Okay, same as prior paragraphs of the complaints. Served alcohol to an intoxicated person at relevant times, but she only allegedly had one drink at the Waterfall, right? So defendant Waterfall violated Massachusetts dram shop laws. And I think the CCTV too at the Waterfall was a lot grainier than the one at C.F. McCarthy's. That one was I think that one was in color too, right? That one was a little bit easier to see, and we actually got to see, like, a close up, whereas, like, her and John the Waterfall video, they're, like, all the way at the top right corner, right, of the video, so it was a little hard to pick them out and see. So who even knows? I mean, who even knows if she bought her own drink, or if John bought her a drink, or his friends bought her a drink? So maybe the person who was also serving didn't know who they were serving. They were just, hey, can you get me 3 vodka or whatever, I've done that before. Defendant Waterfall violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including but not limited to its decision not to hire competent employees. So it's all the same stuff as earlier. Violation to provide safety training, retaining unfit employees. I thought the girl who had the rogue highlights, and I'm not saying that because I used to have it. You look at my Alexasrewm profile, but I used to have the rogue back before it was like a thing, before it was cool again. But she seemed pretty honest. She seemed pretty, I don't know, maybe like she seemed cool. Like, why are you throwing her under the bus, man? Like, she probably got like a family to feed. Like, why are you throwing her under the bus? The defendant Waterfall acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. I wonder what the person, Paul O'Keefe, who was serving you that day when you hit an elderly man while drunk driving in the middle of the day. I wonder what the person serving you. Anyways, the defendant Waterfall acted with gross negligence. The defendant Waterfall acted with willful, wanton, and reckless disregard for the safety of others, deliberately ignored so again, it's all the same. It's copy and pasted. Copy and pasted. Yeah, this is all verbatim the same thing. They demand judgments against the defendant Waterfall on count 2, plus costs, compensatory and punitive damages, lost value, next of kin, and any other relief this court deems appropriate. And then count 3, the one, the only, Karen Reed. Let's get him. Let's get him. On the dates of the the plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety prior paragraphs of the complaint. On the date of the crash and at all relevant times, defendant Reed owed Officer John O'Keefe and the public at large a duty not to drive drunk, to drive her vehicle safely and or with due care. On the date of the crash and at all relevant times, defendant Reed owed Officer John O'Keefe and the public at a large duty to pay attention to the roadway. At all relevant times, defendant Reed breached her duties of care to God, this JJ stuff is like screwing me up here. Officer John O'Keefe by driving drunk, driving in an unsafe manner, and or without due care. As a direct and or proximate cause of defendant Reed's negligence, gross negligence, and or willful, wanton, and reckless disregard for safety, Officer John O'Keefe sustained serious injuries of body and mind. So again, all the same things. As a direct or proximate result of defendant Reed's negligence, gross negligence, his next of kin suffered as. So this is what they're hiding behind his niece. They are literally hiding behind his niece. How icky. How icky. To which the estate is entitled under MGL. Compensatory and okay, so that's all the same. So count 4. Oh, okay. So that's only Paul, right? Sorry. Oh, this is the estate. Sorry, this is the estate that's suing, and now it's Peggy who's suing. Peggy O'Keefe learned of Officer John O'Keefe's admission to the hospital immediately and came upon Officer John O'Keefe's body at the hospital shortly thereafter. C.F. McCarthy's negligence caused the death of Peggy O'Keefe's son, Mark. I'll call her Marge. Marge suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing JJ at the hospital and witnessing the consequences of C.F. McCarthy's negligence. Marge's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by the defendant. Negligence. A reasonable person in the same position as Marge at the time of Officer John O'Keefe's death would have suffered severe and profound emotional distress. She demands judgment against C.F. McCarthy on count 4 plus interest. Oh, plus interest, costs, and any other relief or damages this court deems appropriate. I just feel like it's so vague, though. I mean, like, yes, obviously we understand like emotional distress. You lost your son. I'm not going to argue about that. And for that, I genuinely do feel absolutely horrible. But I believe you can believe in two things. I can believe that maybe I don't know. I don't know Peggy. I don't know her from Adam. I didn't know John. I didn't know his family. I don't know. I don't know. So I don't want to give too much of an opinion there. I know other people have strong opinions about the O'Keefe family. I'm not the biggest fan of Paul based on what I've seen. I feel like sometimes sometimes I feel like he's a little bit hypocritical. Just based on his past. You would think maybe he'd, but I don't know. He's blinded by this pain of losing his brother. I don't know. But I believe two things can be true. Just because you're a grieving mother doesn't mean you're also a saint. And I don't like how we put sometimes victims' families on these pedestals of perfection, or even victims themselves. Nobody is perfect. We are all humans. We all make mistakes. So to put anybody on any kind of pedestal, and even talking about Karen Reed she's a human being too. She's a human being too who's probably made so many mistakes in life just like anybody else. I don't think it's fair to put anybody on a pedestal. Nobody's perfect. So that's why I'm going to be a little bit critical here, because again, it's like, well, what are the physical things? Like, what's the severe physical pain? What physical pain are you like? Are your joints going more? Have you had a heart attack, a stroke? Like all of these things, anxiety, stress, they can all cause physical ailments for sure, 100%. But this is so vague. Like obviously emotional distress, but like what kind of physical pain? Like this is my issue. It's too vague. It's too vague. And then the plus interest, like kind of showing your greed a little bit, Peg. You're kind of showing your greed a little bit. Just a little bit. Count 5. John O'Keefe versus C.F. McCarthy's. So I'm assuming this is the father. Yep. The second, he learned of his son's admission into the hospital, caused the death of his son, suffered severe and profound emotional injuries manifesting in physical symptoms as a result of observing Officer John O'Keefe at the hospital and witnessing the consequences of C.F. McCarthy's negligence. So again, the same thing, physical pain, ailments. A reasonable person in the same position as John O'Keefe II at the time of Officer John O'Keefe's death would have suffered severe and profound emotional distress. And again, I'm not arguing with that, but what's the physical pain? Like what else? Like be specific. Be specific. And then this plus interest, right? So this is all copied and pasted. Now Paul O'Keefe. Brother Paul. I'm assuming this is all the same. But like, Paul, what severe physical pain are you going through? Like seriously though, like let's be specific. And whose idea was the plus interest thing? Because that just like screams greed to me. Then Peggy, and that's interesting too. So this is so interesting. So you like go through all the counts, right? And it's like only earlier that they mentioned the niece. And I guess she's like representative of the estate, even though Paul also represents the estate. So he's still speaking on behalf of, I get she's a minor, but then they're each individually like plaintiffs as well, because they want to get their coin too, and that's also my issue with it. It's also my issue. I'm not saying that the family shouldn't get anything if Karen Reed was guilty, but she's not factually guilty. So I mean, okay, let's keep going. We're almost done with this, folks. Peggy versus the Waterfall. So yeah, same thing. Emotional injuries, severe physical pain, distress. John the second. Same thing with Paul, but then they don't like call out like am I wrong? Is it because I guess they're on behalf, like the estate is on behalf of the niece, but then they each have to be plaintiffs? Like, is there a point for each of them to be plaintiffs? And this is just me speculating. He would probably want it to all go to the niece and nephew, right? I don't know, maybe Karen, probably not. I mean, it wasn't like they were engaged or getting married, but they were in a relationship for over 2 years, right? So, who knows? Who knows? But I imagine at the very least, he'd want probably everything to go to the kids. So I think it's really interesting how they're like, "Oh, well, yeah, we'll represent the estate, but we all want some coin too." I have to wonder because, I mean, Karen was in finance. We know she was setting up trusts, right, for the kids. She probably was helping John out with his finances, so Paul didn't have enough cash to bail himself out of jail, so, I mean, I don't know. I don't know. I just find it really, really icky. Okay. So the Waterfall. So now Peggy is suing Karen Reed, right? For negligent and or reckless infliction of emotional distress. Yeah, this is all pretty much the same. And or reckless infliction of emotional distress. Repeats, realleges. This is the same. Defendant Reed outrageously created a false narrative. A reasonable person in the same position at the time of his death would have suffered severe and profound emotional distress, plus interest. Okay, so again, copy and pasted. John O'Keefe. I mean, I don't know. Like, I would love to hear, because this is the only other time that we've really like seen anything mentioning John's father. I'd be so curious. Like, I'm sure he was probably coaxed into doing this, whether he did or not. I don't know where he lies. I don't know if he thinks that Karen did it or didn't do it. I have no idea what he believes, but I can only imagine that this was probably a really stressful situation all around. He was probably coaxed into it, my speculation, into moving forward with this. Cause of death. False narrative. Okay. Oh, so now they're saying, so I guess the niece is suing. So the niece isn't suing the the estate is suing everything. Then they're all individually suing. And then the niece is just okay. Okay. She was a niece. He was her guardian since her parents passed away. She learned of her uncle's death or injury when defendant Reed woke Kaylee up at approximately 4:30 a.m. on January 29th. Defendant Reed knew Kaylee was vulnerable, having already lost her parents at age 6. Nevertheless, in Kaylee's presence, defendant Reed spoke on speakerphone to various people between 4:30 and 5 a.m. on January 29th. At relevant times on January 29th, Kaylee heard defendant Reed say, Your uncle never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. But I don't remember any of that. I mean, did she testify to this? I know it was a close court. When her and her brother testified. But I mean, was this when she was, like, allegedly on the phone making one of her phone calls? I'm just so, like, to Carrie Roberts or Jen? As a result of the conversations defendant Reed had in her presence, um, the niece perceived the injuries caused to her guardian, her uncle, and perceived the injury-producing event at or about 5 a.m. After waking the niece up and informing her that something happened to her uncle, defendant Reed left her niece, left Officer John O'Keefe's niece home alone. Defendant Reed intentionally and or recklessly. Well, how old was she though? Like at this point too. I mean, like they're like, oh, she left her. I mean, I don't know. I don't know. Was somebody babysitting them when they were out, or were they already home alone to begin with when Karen and Officer John O'Keefe went out? At this point, was she old enough maybe to stay home alone? I mean, I know I did when I was like 14, 15, so I don't think that that's that strange depending on how old she is. Inflicted severe, and not for nothing, was Karen gonna bring her with her and like subject the kids to like panic and everything? Probably not. Intentionally and or recklessly inflicted severe emotional distress when she woke her up and informed her that she hit her uncle or that the snowplow hit her uncle. I mean, I don't know. Did she testify to any of this and say that that's what she said? I don't remember that. Defendant Reed either intended to inflict emotional distress in Keeley or knew or should have known the emotional distress was likely to result from defendant Reed's conduct. Defendant Reed's conduct was extreme and outrageous, beyond the bounds of decency, and was utterly intolerable. Then, after Officer John O'Keefe was declared dead, defendant Reed came to the family house and feigned concern. Rather, it became clear that defendant Reed was only there to collect her belongings and take. Again, this is like what they're so peeved. This is what Paul is so peeved about. And again, not for nothing, everybody grieves in different ways, and we don't know how we're going to act in a situation like that. And if she, in the moment, is having a mental health crisis and a mental health breakdown, like probably most of us would have if we just saw the person that we loved left for dead on the snow, in the snow, in the cold, and we're the only ones who are trying to resuscitate him. That is a freaking traumatic experience. So I really don't like. You can't put too much weight of this. Suffered by the niece was severe and of a nature that no reasonable person could be expected to endure. Defendant's extreme and outrageous conduct caused the niece aggravated emotional distress, manifesting in. And this is the other thing too, because I know some people will be like, "Why didn't you like?" I mean, I didn't read through this document before, so like, and I apologize. I never want to dox kids ever, 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 ever. And sometimes I just don't have a chance to go through these documents and um, remove names. But I mean, the fact that they're naming the niece here, like in this document, like the family is doing that. Like we don't need to subject the kids to this bullshit. Like we just do not. We do not. And I just don't like it. It's icky. And we don't need to name them in these court documents. We don't. If you're so like concerned about keeping them safe and out of the public eye and their anonymity, like this is not the way to do it. This is not the way to do it. And I do apologize. Aggravated emotional distress, manifesting physical symptoms, emotional injuries of perceiving her uncle's death. I mean, I can't even imagine. I can't even imagine the amount of distress that this poor kid has faced in her life. Like, talk about strength. My God. Okay, and then this is the same. Yeah. Okay. So, I mean, like this for me, I don't know, guys. I don't know. What about you? What say you? Does this not stink of like Jen McCabe, like breathing over Paul O'Keefe's shoulder, being like, you should sue, you should definitely sue, and like in cahoots with Peggy, and like it just feels icky and kind of gross to me. And not that I didn't see it coming. I definitely did. But I feel like if you're really in it because you're trying to make right by the people that John essentially cared about the most, which I think we can all say was his niece and his nephew, because those were essentially his kids, his adopted children. I mean, you would think that he would want probably everything to go to them, also being that they've already been through enough. And I just don't feel like why is it relevant for maybe it's standard procedure, I don't know. I'm not an attorney. I don't know how these things work. Maybe you guys, in the comment section, you can let me know if you have experience with civil lawsuits or you are a lawyer. I would love to know, maybe bring you on so you can go through this with me and we can chat more about it. But I just feel like it's unnecessary to like for each individual person to be suing Karen and the Waterfall and CF McCarthy's when I mean, it's especially weak for I think the bars. I know some people are like, "Oh, they're just going to settle out of court just to, shut the noise down." They don't really care about the bars, I don't think. I think for them they're just gunning for Karen Reed, but in order to sue Karen Reed and prove that she was driving under the influence, they also need to sue the two establishments that her and Officer John O'Keefe were at earlier that day. But what say you guys? Do you think that anything is going to happen with this lawsuit? I mean, I don't even know. I mean, I think it will go like it will press forward. I don't think it's going to get thrown out by any means. Regardless of how this appeal goes, I think it will go through. I think it'll just make things even more difficult for the retrial. I because again, they're opening up all this can of worms of more evidence can come in, and the rules are a little bit looser in civil court. So I'm personally looking forward to seeing that unfold because hopefully that means we get closer and closer to the truth of what actually happened. Maybe we do actually get to hear from Karen Reed herself. Maybe not. Will this happen before or after the appeal goes through? Who knows? Who knows? But whatever the case, we'll keep you updated here on Alexa's Room. And with that being said, if you liked today's video, make sure you hit the subscribe button. Make sure you hit that notification bell so you don't miss the next Karen Reed update from me, including our live stream tomorrow, where we'll be celebrating 1K subs on this channel. Again, thank you guys so much. I am incredibly thankful and grateful for each and every one of you who just show up to my channel every day, watch my content, and are just so kind and warm. And that's what this community is all about, is just having respectful discussions, whether you agree or disagree. I know that some people completely disagree with what I think, and that's okay. I think we can have productive conversations and learn from each other respectfully, even if we don't agree about everything. That's the great thing about the world we live in, right? This country we live in is that we do have the ability to express ourselves freely to an extent, and do it in a respectful way and debate, but also learn from each other too. And that's what I'm hoping to continue to build this conversation on, is just this community on, is having those conversations, because having those conversations actually leads to change, actually leads to making a difference in this world, in our communities. And that's what this whole case is about, right? So make sure you hit that like button so we can reach as many people as possible with this story, because the more people we reach, the more pressure we put on the DA's office to do the right thing, the more pressure we put on the state, Massachusetts, and so many of our other state legislators and local governments to just take notice. Pay attention, for all of us to pay attention more of what's going on in our own community. So again, we can make this world maybe a slightly better place to exist in.